some people were a little bit confused. There is a third glass area, which is many people refer to it as the big pile. That is not part of these amendments, and it is not part of this public meeting tonight. We're not, we haven't taken any action on that, and we don't have anything to report on that. So let me do a little housekeeping before we get started. My name is Dennis Feckert. I'm the chief of the certification section in the Vermont State Solid Waste Program. I've been working in the solid waste field since 1993 and been with the DEC since 2001. So back to the housekeeping. As you entered the meeting, you'll probably notice that you're muted. As the meeting goes along, we're going to have a couple presentations, and we'd like you to stay muted just so you can listen to the presentations. And at the end, we're going to have like a question comment period. If you want to make a comment at that time, you'll see a little hand symbol. For me, it's up in the right-hand corner. For some people, it might be right in the middle of your screen. You click on that hand, and that basically your hand is raised. We'll acknowledge you and unmute you so you can make your comment. When you do make a comment or ask a question, we'd like you to keep it to 1 or 2 minutes. Just kind of get to the point, ask your question, and then that way, if there's a lot of people that have comments, we can get to everybody. And if we get to a point where we have time, we'll circle back, and anybody that feels like they didn't get enough time, they'll have a second chance to make a comment. I also would like to mention at this time, as most people in this meeting probably know, there's currently a case at the Attorney General's office about this use of glass. I want to reiterate, this meeting is not about that case at the Attorney General's office. We really can't discuss that case because I really don't know anything about it. I don't know where they are in their process and have no knowledge of how that's going. So that is not part of this meeting tonight. When you do ask your comments and make your stuff, let's keep it civil, and let's be respectful of each other, and we'll just have a good meeting, and maybe we'll make some progress with glass recycling in the state of Vermont. So with that, I'd like to turn it over to the applicants. Sarah Reeves of the Chittenden Solid Waste District, General Manager, and Josh Tyler, the Director of Operations. They're going to give a little presentation on the 2 projects that we're discussing tonight. And then I'll come back and talk a little bit about glass recycling in a general sort of way. So go ahead, Sarah.
Great, thank you very much, Dennis, and thank you to you and Ben and to the agency for providing this public meeting so that we can do comments on our 2 minor amendments for our 2 projects. As Dennis mentioned, my name is Sarah Reeves. I'm the Executive Director for the Chittenden Solid Waste District. And with me tonight is Josh Tyler, and Josh is our Director of Operations. And just to reiterate, Dennis, what I heard you say as the purposes of the meeting, it is my understanding that the purpose of the meeting is to accept comments that will inform the agency on the minor amendments for these 2 projects. And that we are happy to answer questions about these 2 projects. And again, to reiterate that we will not be entertaining questions about other projects in this venue. And at this point, I'd like to turn the camera and the microphone over to Josh Tyler. And Dennis and Ben, I believe Josh would like to have permission to share his screen so that he can go through our very brief presentation.
Can everybody hear me clearly? Thumbs up works.
Yes.
Okay. I am bringing my screen up. Worked beautifully a second ago. Can everybody see that?
Yes.
Okay. So I'm going to present on 2 of the minor amendments. The first one I will present on is our closed landfill cap repair. The ID number for the permit and amendment is included. This is a site plan showing that the project took place in Williston, Vermont. There's a locus map indicating where Redmond Road is, the Winooski River, and our approximate phase 3 landfill. So just some bullets on the project. The project took place on CSWD's phase 3 closed landfill, which is in a 30-year post-closure care plan. Once a year, we have an engineer's inspection, and in 2011, a settling depression was identified. The bottom right corner was the picture that was taken. It's really hard to see, but in the kind of the center left is where the settling was. We developed a project to correct the observed depression. It was identified as typical settling. We reached out to consultants and to a construction company to develop the project. The project bid was awarded to the tune of approximately $150,000 in 2012. The project work commenced in 2012 in the fall, and it was completed in the spring of 2013 because we had to stop during the winter. If you look at the top right, I've got a grading key. And what we wound up doing for this project was we removed the 18-inch vegetative cover layer. We pulled up the non-woven geotextile membrane. We removed the 12-inch sand drainage layer that got us to the 40 mil textured LLDPE geomembrane, which is the cap. We cut that out, and then we removed the 6-inch gas vent layer. That was where we reached a fill layer, which is above the remaining 6 inches of existing sand gas vent layer. In that fill layer, that's where we added the material to bring us up to grade to solve the depression. Then we put everything back together. The picture I'm showing you here, the green outline and the yellow inset outline, that is where the project took place. We brought it up, we brought the settling back up, and it has maintained its existing grade ever since we completed the project. That is the minor amendment for the landfill cap repair. The next project took place at Green Mountain Compost in the South Field. It was site work. The picture you're seeing here in the center is the South Field. So at our organics diversion facility in the South Field, which is permitted for composting operations, we identified that we needed to develop the South Field for a workable surface. In 2014, we brought in fill, sub-base fill, to develop the site for leaf and yard waste windrowing. And then in 2016, again, we expanded it a little bit in anticipation of excess feedstock in regard to Act 148's implementation. We knew we needed more room. It made sense at this area to expand because we were permitted to do it. We graded the site and we developed a uniform slope. So what you're looking at here on the left is the slope in 2000, or is the site, the South Field in 2014. In the inset on the bottom left side, you can see the contours indicate that there was a knob and it was contoured and sloped relatively a little bit steep. On the right, the site plan with the blue contour lines shows that we had flattened the area and graded a consistent slope for stormwater management. That was the basics of the project. We moved some sand around and we added some sub-base. That is the end of our presentation for these two minor permits. I'm going to stop sharing my screen.
All right, well, thanks for that, Sarah and Josh. And I just want to talk a little bit about, let's talk about the glass that was used. This may be a little bit remedial for some of us, but it's probably good for all of us to see. I want to see if I can share my screen. I don't know if you guys can see that. Basically, this is, let me just see something. Are you seeing basically it's the definition of what processed glass aggregate is on your screen?
Yes. Yes, we are.
Okay. All right. Thank you. You see right here, this is, we take our, what becomes processed glass aggregate from the Agency of Transportation. This is what they use to determine if something meets that category. So just real quickly, it contains no hazardous waste, no more than 5% contamination by weight for china dishes, ceramics, or plate glass, or 1% contamination by weight from plastics, papers, or other objectionable materials. And the PGA must be crushed such that 95%, and the parentheses are mine because 25 millimeters didn't really mean too much to me, but 25 millimeters is basically an inch. So any glass that's bigger than an inch won't go through the screen. It's too big. It has to be less than an inch. And then the rest of that, what you're seeing with the 3% and all that, basically it comes down to there can be very little dust because the dust is a hazard for workers. You know, AOT is using this for sub-road projects, so dusty conditions are no good for the workers. So let's say you meet that PGA standard. These are the acceptable uses for PGA listed here. And what I mean by acceptable use is the state has determined if you meet the PGA status, you can do a project with your PGA, your processed glass aggregate, and you do not need to get a permit from the agency. You don't even have to inform the agency of what you're doing because that is an acceptable use for that material. So you can see that you know, if the agency at this time felt that the glass in question that we're talking about tonight was PGA, then the district would not, we wouldn't be in this meeting tonight, and the district wouldn't have to apply for a permit. So now we have a situation, I'm going to switch over to here, where when glass doesn't meet PGA, now what do we do with it? Well, currently in the state of Vermont, basically your only option at that point is to take that glass to another facility that will process it further. You could see basically you can bring it down to like a 2M to materials like that. In order to use the glass, you can go beneficial use, glass aggregates, stuff. There is other stuff you can do with the glass, but you have to meet the standards. So what we're looking at in these projects where the glass, the liner repair and the south field, these were real bona fide projects that needed to be done. They used this glass and they have performed over the years, they've performed successfully, and it seems like it has worked out well. So that's the position that we're asked to do. Can we permit this activity? So pull up something else. So I guess at this point, we'd like to, if anybody has a comment or a question on these projects, we'd like to take that now. If you could, you know, use the hand to raise your hand.
You're still sharing your screen.
Oh, am I? Sorry. Yep.
Hey, Dennis, this is Ben. I just wanted to have a couple quick announcements here before we begin the comment section. let me grab one thing. So the idea is, like Dennis talked at the top of the show or the meeting, that the idea is to try to give everybody an opportunity to ask questions relating to the applications themselves for these projects and for the draft certifications or draft amendments that we've posted to the environmental notice bulletin. I don't know if folks are aware, but all the documents, the applications and the draft amendments are available in the environmental notice bulletin. I'll post a link to the ENB and the PIN numbers for the two projects in the chat in just a moment. I think one important point to make is the idea here is that this is an opportunity for folks to ask for clarifications, ask questions to inform the forthcoming public comment. So as you know, the public comment is open until November 10th, I believe. And this is an opportunity to get questions answered to be able to submit the formal public comments. This meeting, neither the chat nor the discussion that happens here is going to be accepted as a public comment. So anything that you want to submit as a formal public comment has to come in as a formal public comment through the ENB or by emailing directly to Dennis Feckert at vermont.gov. I think that's all I had. One last note, in the interest of time, I'm going to be running a 2-minute timer. If anyone approaches the end of the 2 minutes, I'll give you a warning that it's 20 seconds left, and then you have an opportunity to wrap it up before you can move on to the next person. As Dennis mentioned, we'll allow, if time allows, we'll circle back and let people come back and ask any follow-up questions that need answering. That's it. Thank you very much.
And Ben, will you be the person that unmutes people?
I am, yep. Yeah, we got a
Okay.
couple hands up. I will let in. Looks like Melissa Patterson has her hand up. And Melissa, go ahead and unmute yourself and go ahead and ask your question.
Okay, I just have I'm Melissa Pedersen, I'm at the Newport City Council, and I just have two clarification questions. The definition of a qualified consultant, what would make someone to be, a qualified consultant? And then my other question is, what is the process for opening a closed landfill? Is it the process is to do what you need to do, obviously, because you had a problem with the settling? Do you do the work and then ask for amendment? Or what is the process for doing that? Those are my two clarification questions. Thank you.
Very good. Thank you.
Yep. Thanks, Ms. Pedersen. For your second question, so basically every post-closure landfill certification has a condition that says you must maintain the integrity of the cap. As a matter of fact, about a year ago today, we had a Halloween storm that a couple closed landfills experienced erosion problems and runoff that came off and damaged the cap. Well, those townships, they were allowed. What they do is they just go in and they fix the cap because they're maintaining the integrity of their cap. They don't even really have to notify the solid waste program that they're doing that. And then every year there's an annual inspection, and during that inspection, we make sure that the cap repair was done correctly. So that's the answer to that. A qualified consultant can be. It depends on what it is you're consulting on. For example, we have consultants that work on compost facilities and design how the facilities work, and there's just kind of like experience in the field and how long they've been doing it. There are engineers, there are engineering firms that are qualified consultants, things of that nature. It's generally people with experience in the field that we accept.
All right. I think the next hand up is John Brabant. John, go ahead.
Hi, can you hear me?
We can, yep.
Okay, hi. I'm representing Vermonters for a Clean Environment. Thank you for having me. I got a number of questions, more than I will be able to fit in tonight, so I will save the rest for written comments. But these are questions all my questions are going to be for Dennis Feckert. Dennis, So you said that the CSWD Chittenden District used glass aggregate. They emplaced that under the landfill cap. Yes?
Yeah, glass processed at the MRF
Okay.
underneath
Yeah,
the cap,
right.
yes.
Okay. So is that considered recycling to do what they just did?
I would consider it reuse more than recycling.
Oh, okay. So if it doesn't meet the PGA spec, it's still considered reuse or recycling? That's my question.
I think that's possible, yeah.
Well, you should know that because you have a draft permit out. Okay, thank you. Now, I see that in your findings that you've waived the engineer's certification. Why was that? Other than because CSW asked, did they provide you a reason, a rationale for why it needed to be waived?
Well, because the project was designed by Sanborn and Head, a very respected engineering firm. Also, the employee at the time, at the time of the repair, Mr. Brian Wright, was a engineer. So I looked at the waiver of the engineer requirement as for the application that I saw, not for the actual project itself.
Okay.
The project itself had been completed 7 years prior and seemed to be well engineered.
So okay, I know, but did Sanborn and Head or Brian Wright certify that this was built to standards?
We have 20 seconds left.
Oh, come on. Half the time, my time is spent by Dennis
Well-
looking for his phone here. Dennis,
What's that?
did Sanborn and Head certify this as meeting standards? Was there an as-built set of plans, engineered, stamped, and certified? And I'm going to ask
I
you a
don't
number of
think there,
questions.
I don't think there was an engineer stamp.
Okay. Was there destructive testing or air pressure testing on the seam that was the reseaming of the cap? You should know that,
I don't.
Dennis.
Yeah, I should know that.
Yeah. Okay. Well, you just answered my question. The answer is you don't know. So
All right,
no
John,
engineer
that's the end of
certificate.
time. We're going to move on to the next questions. Thank you for that, the questions for clarification. Looks like Patrick Austin is next. Patrick, you may have to unmute yourself. There's a microphone.
hear
at
me?
the- There you
Yeah,
go.
can you hear me?
Yep.
So my first question is a follow-up on Melissa's. Dennis, you responded to her saying that when there's severe storms or there's issues with landfill, post-closure landfills, they're allowed to fix them issues and move on. Are they allowed to actually open that cap up when it's not been disturbed and deposit material inside of it?
No, we would expect to be notified for that.
Okay. Do you know if it sounds like in this situation that is what happened, that they had pulled back the material on top of the cap, opened the cap, deposited the material inside of it, and then reclosed it?
That is correct.
Okay. So my next question is, you had talked a little bit about how this material was seemed like good material to use for this process if it met the PGA spec. Is there other material that Vermonters send to Chittenden Solid Waste District to be sorted and recycled, or to have the most beneficial use sent to this type of use, say tin, plastic, paper, or is it just glass that is used for this type of thing?
I would say it was just glass because of the inert nature of glass.
Okay. Do you, I know they have to report, I don't know if it's yearly or monthly or quarterly, on the condition of their landfill. From the reports I saw, and maybe you can correct me on this, was there specific issues with that landfill that were reported to the Agency of Natural Resources that needed to be corrected?
Yeah, the depression on the cap was noted. And it,
And
go ahead, Pat.
that was inspected by your staff as something that needed to be breached and left open for seems like months to deposit this material into it. That was a justifiable breach of that cap as an issue that was reported to your staff.
There's about 20 seconds left right now. Just
No, there was, that's part of the issue here, is that we were not notified of the project.
Yeah, and if you think this, you had stated real quick that this was seemed like a good use of this material. I'm just questioning why the agency would issue a notice of violation when they found out about it, because it was happening behind the scenes. Why you would issue that and then consider permitting it after the fact?
Well, the policy with the solid waste program is if there are two outcomes. You can either get a permit, or you must remove the material. So, we do this sometimes if a township, for example, maybe buries some concrete where they shouldn't have buried it. If they can meet the siting requirements, we'll give them an approval to bury it. If not, they have to remove all the concrete. So that's the situation we're in right now. We can permit this activity, or it's possible that all the glass has to be pulled out from under the cap, which would be probably the most environmental harm that could come from this project, would be to do that.
So I know I'm out of time, and with all due respect, I know I'm out of time. I would like a little bit of more time. I do have some more questions, but this is not anything like concrete being disposed of. This is material that come out of a MRF directly, and there's other environmental issues. So I would like some more time. I am an elected official. That's why I'm here to report back. I know you're trying to limit everybody's time, but you have 2 permits here. We should get at least 4 minutes. I know that some on the staff don't want people to be able to ask questions, but I appreciate that.
We're going to come back to you at the end. Thank you so much. Next hand is up. It looks like Denise Wheeler. Go ahead, Denise. You may need to unmute yourself, top right microphone.
Yeah, I got it. So I'm going to ask one process question real quick, and then I may have another question later. So I want to have my time counted. So you said this is a public informational meeting. This was warned as a public meeting. Are you not taking? Are you taking minutes of this meeting? That would be added to the record.
The meeting is being recorded. I'm sorry, I should have mentioned that earlier.
So it seems like then, if this is a public meeting, then that documentation should be added to the file, so that not everybody has to try to send in written comments.
Oh, yes, yep, that's possible. What I would have to do is listen to the meeting and just transcribe people's comments down, which I really, I don't have a problem doing that. It's just that
seems like that would be efficient to have. Yeah. There's a lot of people on this meeting, and it seems like if everybody has something to say, that should be part of the record.
Yep. I think Denise, I agree with you. I think it is part of the record. I don't think historically we've done these meetings in person, so it's not, usually people would have to submit public comments formally. So that's just sort of the precedent that's been set in the past. So just a heads up.
Not true.
Okay, and so I would give the rest of my time, my minute, to John Brabant. And just for the record, I'm from the Calais Select Board.
Okay, thank you. And I think we got another hand up. So
yeah, but I want you to give the rest of my time to John Brabant.
That's not how we're doing things. We're going to answer let people that have their hands up have an opportunity to speak, and then we're going to circle back. It looks like we're going to have time to circle back anyways. So I don't think it's going to be an issue if people want to ask some more questions and have some more time.
Yeah.
Thank you very much.
Well, we'll hold you to that.
Paul Burns.
Hi. I am the executive director of VPIRG, the Vermont Public Interest Research Group, and it is on VPIRG's behalf that I make these comments. First, the 2-minute requirement is unnecessarily brief for this process. That's a comment, not a question. The question I have is, do you consider a request for the retroactive permits in this case just as though you were considering a prospective application? In other words, just based on the merits, you're trying to put yourself back in time and thinking about what would happen? Is that the way you consider this?
That is, but sometimes you have to look at what has occurred since then. So I mean, had they come to us at that time and asked to use this material, there might have been some back and forth. There might have been a request to maybe do some additional screening, and we would have eventually gotten to yes. So you have to take what has occurred in as part of the whole process. So nobody likes to do an after the fact. I certainly don't like to do it. I don't, but that's where we are. It's the job. So you have to think about where you are today.
Can you think of other occasions where you have issued an after the fact permit?
Only the example I gave earlier, like of somebody, burying concrete when they shouldn't have.
Okay. So I agree that this should not be considered in just the same light, that you have to look at what has happened. I also think it's important to consider the actor in this case. If you don't consider it differently than you would a prospective application, then you may be unintentionally creating a perverse incentive for somebody to act intentionally without a permit. In other words, shoot first and ask questions later. And I don't think that's the kind of incentive that the state environmental agency should be providing. And I fear that's what could happen in this case. This is also a situation where you have an applicant who is very sophisticated. They have all sorts of professionals on their staff, from engineers to lobbyists to lawyers. They have worked with ANR for many, many years. They know that a permit would have been required for this kind of activity, and they still didn't request it. We're not talking about one time, we're talking about at least 3 in this case. And that, I think, should also be considered, because you're thinking about the trustworthiness of this applicant. You also know that a former employee has gone on record with devastating information about CSWD's activities in dumping of glass near the old landfill there. I understand that's not
20 seconds left.
That's not what this application is about, but it speaks to the track record and trustworthiness of this entity. Dumping this glass without a permit violates the public trust and threatens public confidence in recycling. I believe it's an environmental violation and a violation of Vermont's consumer fraud law. And without, and I know we're not talking about enforcement activities here, but in the absence of any enforcement activities, to simply grant these retroactive permits sends a very bad message. And I fear that the public confidence in recycling and in a trust that our government will stand up to polluters who do the wrong thing is at risk here. Thank you.
Thank you, Paul.
Thank
we
you.
got another hand up. And Paul, for the record, I agree. I think the 2 minutes turned out to be a little short, but we just wanted to make sure everyone had a primary opportunity to speak in case there was a lot of attendees. Marie Thomas, go ahead.
Can you hear me?
Yep.
Okay, I would echo Paul's comments. And I used to work for a regulatory agency. I used to work for the Army Corps of Engineers. And I know a lot of people would come in and ask for after the fact permits. I would say that none of these environmental laws are new. And the Chittenden Solid Waste District should be a very professional organization. They should be aware of everything. And they should not be let off the hook. There needs to be some kind of penalty or close monitoring or something. You just can't let people get away with doing things without speaking. They're a public utility. They are serving us. A lot of us work very hard to try to do the right thing by the environment, and we need to trust them. And right now, this is on top of some other things that they've done. I don't have a lot of trust in them, and I'm just wondering where my money is going when they come to my town and ask us to support them. I'm just wondering why we should be supporting them if they're not acting in good faith. So that's my comment.
Thank you for that comment. Really do appreciate that, and I do appreciate Paul's comments and John's and Pat's, and it definitely we hear you.
All right, looks like Annette Smith has a hand up. Go ahead, Annette.
This is Annette Smith. I'm Executive Director of Vermonters for a Clean Environment. I'm missing something here. Why are we talking about an activity that happened 7 years ago that has not gone to enforcement instead of a permit? And I would think that there's a process here that needs to be followed. And when did it come to the agency's attention that this activity is, cutting open a sealed lined landfill? It's not a minor thing. When did it come to the agency's attention that this activity had occurred?
There actually, there is an enforcement case going on right now. The agency actually sent it to the enforcement. So that's, that's where I kind of feel a little hamstrung. That's occurring right now, and we're not talking about it, and we're, so.
Well, I'm a member of the public, and I'm talking about it, and I think that there's a logical step that should happen, which is that should be resolved before we start talking about issuing a permit for an activity that should have come to the agency's attention before it was done. But you didn't answer my question. When did this come to the agency's attention?
I cannot speak to that. That was our enforcement person, and it's been there for a while, but I can't tell you exactly when, when that went to the AG's office.
What's the urgency of doing anything about these permits right now? Given that enforcement, I don't know how long it's been going on. You don't seem to know, but what's the reason why this is now coming before us, taking up our time, when the enforcement really should be resolved first?
That's a great, and you're preaching to proceed in some aspects, but
well, why couldn't the agency then just,
I have an application and I have to, proceed with it.
Why do you have to proceed with it? I'm like I said, I'm missing something here. There's a piece that I'm not understanding. You say that some enforcement's been going on. You don't know how long. You've got a permit that you have to review. Can't this permit be placed on hold until the enforcement is resolved?
About 20 seconds left.
Yeah, I mean, I can take that to, to the higher ups and see what they say. But, I appreciate your comment, and it's a good one.
So I've spent a certain amount of my time waiting for Dennis to answer. So we've been talking about.
And I think we're just going to make sure everyone has their first 2 minutes, and then we're going to circle back. So
I want to. Everyone else, that 2 minutes is. When I see that
I understand, but we established that at the get-go, and I want to give everybody that hasn't spoken an opportunity to speak, and then we're going to circle back and do follow-up questions until the meeting ends. But thank you. I understand it feels really short in hindsight, but that's what we started with. Okay.
Yeah.
Does anyone else have any questions? Anyone that hasn't spoken yet that wants to ask for clarification or comments or anything? I see Pat's hand up. Pat has already spoken, so we're just going to see if there's anyone else.
No, let's start over and let Pat go.
No, we got Maeve Power. Go ahead.
Yeah, I just have a comment. I'm Maeve Power. I live in Burlington, and I also oppose, like everybody else here, ANR giving CSWD retroactive permits for what seems to be, an act of illegal dumping. And though I understand that there might be financial motivators behind those actions, it's pretty unacceptable for Vermont's laws to be broken and for there to be no consequences. And I know we're not talking about enforcement here, but That's just, it seems silly to give them permits before that conversation is had. I assume the ANR and, AG's office have already put a lot of resources into investigating the issue. So for that to result in really no repercussions is just irresponsible, I think. But appreciate you all having this conversation, and I'll pass along back to the others.
Thank you.
All right. Anybody else that hasn't spoken that wants to have an opportunity? I don't know if there's other folks from the agency or for Chittenden that want to have a moment. Just raise your hand. Otherwise, we'll turn it back over to. I guess we'll start with Pat. Okay.
Ben, it looks like Maria.
I thought that was a duplicate. We'll just go through in order. Go ahead, Pat.
So, yeah, Ben, thank you. Your reluctancy to take more comments from me is noted. It is ridiculous. Scary, you're taking up my time. It is ridiculous that you would put a time on public comment when there doesn't seem to be a time issue here. I don't know if it was Dennis's idea, your idea, Kathy Jameson's, or all the way to Julie Moore, but it makes no sense. But that being said, in 2009, Chittenden Solid Waste District had been caught for doing this very exact activity, disposing of this same material without a permit, and the agency made them clean that material up. I have a question for the agency and then one for Sarah Reeves, Chittenden Solid Waste District. The one for the agency is, when you've already been down this road, why would we be discussing allowing this activity again when they did it behind your back? For Sarah Reeves, you weren't there then, but you are now. Why would your district think that this is now okay to do this with Vermont's recycled glass? Vermonters spend thousands of dollars to haul this material to the MRF from the northern part of the state, and in good faith that this will be recycled. And I want to know why that your board, your chair, or you as a director, Sarah, thought that this was the right activity to happen with this material. And I'll start with you, Dennis.
I'm sorry, Pat, what was the question?
The question was, 2009, the agency went down this same road and forced the Chittenden Solid Waste District clean this material up. Why would you even consider permitting after the fact of the same thing? This is like, say I shot a deer out of season and they let it go the first time and I did it again. Let's let it go again.
Well, we're here to just take your comments and,
But my question was, why would you consider it? Why would you consider it? Why would your bosses? Why would Julie Moore? I know why Kathy Jameson would, because she's. I've dealt with her a lot through this process. This is where the 2-minute thing come from. Let's stifle everybody's comments.
We'd like to keep it civil, please.
What did I say wrong? So my question is, why would the Agency of Natural Resources, one of the biggest entities in state government, the one that is in charge of our resources, our environmental resources, consider permitting this after the fact when this same entity has already been caught doing this and forced to clean it up in 2009? And this happened after Act 148, the statewide recycle law that was going to recapture our resources. So my question is, why would we consider this?
Well, Pat, this actually occurred before the 2015 ban on glass in the landfill. And just to speak plainly, to take the material out of the landfill would probably be the biggest environmental impact of this whole project. So that's something that the agency has to think about. The number one job is protection of human health and the environment, and to pull the glass out is when you're exposing the environment to the most risk.
Yeah, and so breaching that cap was not an exposed. So maybe a huge fine to offset the cost savings this district realized in the revenue gained from Vermonters. But if we permit it after the fact, it's let them off the hook.
That is not the case. Like I said, the two things are on a separate track, and that is not the case. But I take your point, and that's a point well taken.
Okay, I guess, Sarah, I'd like to know why your district felt this was the best course of action again after they had already been down this road.
Well, again, Pat, as you mentioned, I was not here at the time, and Dennis, I just wanted some clarification, and from either you or Ben, about again that this meeting is about these two projects. So clarification as to I guess the relevance of the question when we're talking about practices that predate the projects. Just clarification from my end, please.
Well, I mean, I think he's given historical context to, you know, making the decision making that's occurring. We're still just talking about these two projects, though. I don't know the 2009 incident. I'm not aware of.
Right. So
let's
go ahead, Pat.
go ahead, Cap. No, go ahead, Sarah.
No, I was just going to reiterate again. The projects were done prior to 2015. They were done prior to my arrival. Pat, I'm really not sure what you want me to say.
So the NOAV was issued, I believe, somewhere in 2016. But I guess to Dennis's point about the environmental impact of reopening the cap of the landfill and taking that material out and actually processing it, what about the material that was brought to the compost facility and used to level a place to process compost? That was the best use of Vermonters recycling glass. I will remind everybody that when you recycle material, you need to wash it clean. Vermonters across the state wash this material clean, put it out at the curb, and paid a hauler to collect it and take it to a MRF to sort. Paid the MRF to take it. You know, we're not a rich state. We try to do the right thing. One of the reasons the state pushed this very tough law into place, and that material ended up at the facility that was supposed to be knowledgeable on how to process and move that material, and their answer was to push it into a landfill, under a landfill cap, create a flat spot at a compost facility, and I know we're not talking about it, but use it for bank stabilization on a landfill bank that had no issue. I know I'm just an average Vermonter. I'm an elected official. That's why I'm trying to get answers for my community and for our district. And I just can't understand why I'm sitting here with the Agency of Natural Resources trying to make somewhat of a case for the Chittenden Solid Waste District on what they did wrong, and having them limit the time of people that are asking the tough questions. So when I say that, is there a reason that you, Dennis, agreed to limit the time of somebody like me or Paul or any of these other people that would want to ask questions that nobody wants to answer?
Hey,
Speaking of
Dennis,
which,
can I just jump in? Dennis, you okay?
Yeah.
Hey, Pat, listen, I'm Chuck Shore. I'm the director of the Waste Management.
Oh, great.
We thought there was going to be a ton of people here. We wanted to give everybody a chance to make a first question. You're going to have plenty of time. We have till 8 o'clock. So the 2 minutes, we agree, was probably too short. Let's move on from that. You're talking now. No one's cutting you off. We're going to give you as much time as you need. We're here till 8. So let's move on from that. And I just would like to reiterate again, there's two separate tracks here. The agency obviously felt very strongly about things you're saying because we referred this case to the Attorney General's office. That's going on. That's not been resolved.
there's a lot of suggestion that Chittenden Solid Waste District is getting away with it, with something. That's not been resolved. So I think let's put that in your back pocket and wait till the case is resolved. And then if you're upset at that point, I think that's a legitimate comment. But obviously the agency felt strongly. It's with the Attorney General's office. That's pretty significant, and we'll go from there. But we can't talk about the case because it is in litigation. This is about those 2 permits. It's after the fact. Not something we like doing, but we're in a position, we received applications and we tried to look at it, like Paul Byrne said, retrospectively. If this application came in, how would we handle it if it came in the way it's supposed to? So that's what we're here for. I appreciate all these comments, and you'll all have plenty of time. So I'm going to get off my soapbox and let's continue.
Thanks, Chuck. And with that, it looks like we got a couple new hands up too. So
because I weren't going to get cut off, Chuck, I really appreciate that. Thank you very much for allowing all of us to talk. I have a lot of respect for you, and I have a lot of respect for Dennis. Ben, I don't know you much, but I do agree that you guys felt passionately enough to do something about this. I don't agree that some in the agency weren't aware of this activity for quite some time. I'm concerned that there is a political or some back channel motivation that would allow this after the fact permitting, which is why I'm asking these tough questions, because if this is permitted after the fact, yes, there's still a case going on in the AG's office, but that would drastically change that case, because now the case would be made that, oh, well, the agency of natural resources seems to think this was okay, so it's not really that big of a deal. So, I mean, I don't mean to disrespect anybody at the agency. Chittenden, I've lost almost all respect for, and I don't know where or who is making these decisions to make this happen, but I've seen a lot of information in some public records requests that are downright disrespectful to Vermonters. And it's not what Vermont stands for. It's not what you, Chuck, or Dennis at the agency stand for. And I think that's why people like Paul and us are asking these questions. So with that, I'll pause.
All right. Thank you both. I think we got a couple new hands up that I would like to allow them an opportunity. Paul Tomasi, go ahead.
Hi, this is Paul Tomasi. I'm the Executive Director of the Northeast Kingdom Waste Management District in Lindenville. I have quick questions. Ben, at the top of the meeting, you mentioned the public comment period. Could you repeat that?
You're breaking up a little, Paul.
Can you repeat the end date for the public comment period?
Yes, November 10th.
Okay. And then 2 other quick questions. If you could maybe follow up, twice now you've mentioned that removing the glass would have more of an impact than placing there. Could you explain, why you or agency feels that way?
Well, Paul, I just think, back to almost to Pat's point, you're going to open up the liner again. You're going to have to dig out the glass, which 7 years later is probably integrated with the waste mass. You're going to have to remove that, and then you're going to have to put something, maybe clean fill, I don't know, sand, something back to replace the mass you removed, and then close up the landfill again. So I just feel like that's an opportunity for environmental risk right there.
So just to sum that up then, basically continued impact of the landfill is kind of the concern there. Disturbance of the landfill.
Yeah, I guess you could say that. I mean, it might be, who knows? It could be a rainstorm while you got it all opened up.
Right. And my last question is, how will issuing a permit impact the enforcement issue from the AG's office. I mean, it seems like there's a kind of a chicken and the egg situation here where one could impact the other, and I know we're not talking about the other, but it seems like you can't really pull these two things. That's more of a comment than a question, but it just seems timing permit being issued could impact each decision and vice versa.
Right. Well, yeah, thank you for your comment there, Paul. Point well taken.
Is that all set, Paul? Steve Gorelick, I don't think you've had a chance to speak. You want to go ahead?
Yeah, actually, it's Paul addressed this somewhat. It does seem like several times it's been said that there are two separate tracks. There's this permitting track and the enforcement track. And it seems to me, just as an outsider, that it's totally inappropriate to issue this permit while the enforcement action is still underway, because it does send the message that this was a minor amendment, which is how it's been described, and it was approved by, it will have been approved by ANR, and it will completely take any teeth out of the enforcement effort. So I can't see any reason why a permit would be issued until the enforcement action is completed. And doing it any other way seems completely inappropriate. Thanks.
Thanks for your comments, Steve.
All right. Thank you, Steve. John Brabant, go ahead.
Are you going to unmute? Okay, I'm unmuted now. Thank you, Ben. So I probably had the shortest amount of time, but I know we've moved beyond that. Thank you. I need to get back to my original line of questioning. Were there, after the post-construction plans, as-built plans submitted as part of this application, Dennis or Chuck, that were
John,
signed
you
off?
saw the application documents.
That were can I finish? That were signed off by a registered professional engineer, as-built that would, one, confirm that the landfill cap was reseamed according to standards. Those standards include, oh, by the way, folks in the audience, I used to do this for a living. I used to write permits for these landfills, and I'm very aware of this process. So, by the way, that the engineer's overview and review process and as-built plans and certifications confirm that there was what they call destructive testing. You would normally cut a patch of that seam out, and they take it to a lab and they try to pull it apart, and that confirms the integrity of that seam. They also are supposed to, the seam is two-sided. They're supposed to put air pressure in there and hold that air pressure for a certain amount of time. That again confirms that the welding of the seam was done right. Do you know that that work was done, Dennis, and was an engineer certification on signing as-built plans submitted as part of this application?
You saw the application that I saw, John. So,
okay.
No.
So I want to first say that is highly unusual and very dangerous and never done. So this is a first, and it does beg a question why you would do that. What is the urgency, as Annette said, to rush through something to this degree? You do not know whether that seam or seams were reconstructed or welded appropriately, and there's no engineer certification backing it up. I will note that the Secretary Moore is a certified licensed professional engineer in the state, and this is going out under her name as an engineer. So she would be blessing this new approach. that's the first thing, I guess, of a statement and of concern, and a request that you reconsider this, what I consider actually reckless and unprecedented move to permit this thing. Once it's out, you can't take it back, Dennis. The liability then shifts to ANR. You guys said this was appropriate. You guys now own it. You got one last chance to pull this back on that front. I do also question why a stellar firm like Sanborn and Head, if this thing was done right, done appropriately, would not feel comfortable putting their engineer stamp on this. I also do question, I looked at the application, Dennis, thank you, why the in-house engineer didn't feel comfortable submitting his own engineer's certification. I think that's also telling. And I think, and I would suggest, because the process is still open, that you go back and request of the applicant, and by the way, this has been done before too, where we have insufficient materials submitted and the process moved too fast. It's not unprecedented, and it's happened numerous times in the past where ANR, Solid Waste Program, goes back saying, based on comments and new information, we need more information, i.e., what's the justification, CSWD, for not providing an engineer's certification? Where is the documentation, as-built documentation with an engineer's certification, and why don't we have that? Did you put a safety layer between the glass and the liner? Maybe that was said and I missed it. There's some other things I'd like to say. As you know, folks at the agency on the meeting tonight are aware, I submitted a public records request, and it was recently delivered. I did a rush review of it, and it's very clear the conversations that weren't redacted between agency attorneys and agency staff, including you, Mr. Feckert, and Kathy Jameson and Chuck Schwer, indicate very clearly that the effort is to mitigate and limit the exposure of Chittenden Solid Waste District from enforcement penalties and the need to actually clean up this. And there was a lot of parsing of the language in terms of whether this is PGA, the glass that was shoved under the cap without the agency's knowledge, whether that met PGA standards or not. The application says, we don't know, the applicant didn't indicate that as such either way in the application. Again, why didn't you request that information? We know the answer to that. Let's see. So regarding Annette's question, why you haven't stayed permitting, I would also add to that, why right in time with you investigating this and having detailed evidence of serious environmental transgressions at this very facility, the MRF facility, why you then give this same entity a $500,000 grant, pushed right through the process. Little education for you guys. The process under the law that's anticipated is you don't go to the settlement table and try to get a settlement for something that you can't settle. It's too costly. It's over $1 million in penalties and cleanup costs. It's actually closer to $2 million. They will never settle. They'd be crazy to. So you have no stick, ANR. You go into a dogfight, into a fight with your hands tied behind your back. The process that you're supposed to employ is you file an administrative order issued by the Secretary of ANR in Superior Court, or the agency or the Attorney General's office can do the same. At that point, included in that administrative order, you request a stay of permitting, and you have that authority to do that, and you stay any permitting for this entity anywhere in the state, not only at this facility site, anything they're involved in or they have their name on would be stayed. And that's a further incentive to get this thing rectified and or get them to settle. At that point in time, when you have the order filed, the judge says, parties, have you talked settlement? No, please go have a discussion and see if you can work it out. If you can't, we'll see you in a month. That's how the process works. The agency then has the upper hand. They've withheld grant monies, one, for their composting facility. They've got a pending enforcement action. They've stayed permitting. That's how you do it. The fact that the agency rushed and their attorney rushed the settlement table, and after a year and a half, 2 years, haven't gotten anywhere. And by the way, all indications are that Chittenden Solid Waste District has made
I think
clear.
we're trying to limit questions to the application and the draft permit amendments. This seems like it's gotten a little off topic, but I just want to remind you.
Okay, yeah, I'm sorry about that. So I guess in summary, I would ask that the agency file that ask their attorney, the Attorney General, file an administrative order in court and stop playing footsie with an egregious violator. The agency needs to pay attention to the breach of public trust, as Paul Burns from VPIRG said. It's serious. Just my solid waste district alone, the Central Vermont Solid Waste Management District, over the past 15 years since they've had mandatory recycling, has invested over $1.5 million in staff and benefits toward recycling education and outreach. This undermines it. Why would anybody recycle a single glass bottle going forward, knowing this is going on? And by the way, I still don't believe this glass is being recycled. It's being, quote unquote, stockpiled over at Griswold, the stuff that's coming to their MRF now. And I don't believe the agency has had it tested or required it to be tested.
Again, John, this doesn't seem pertinent to the amendment or the application.
It's pertinent to the MRF that produced the material that was stuffed in this landfill and dumped at the composting site. So I want to ask that you folks stop rewarding this behavior and do your jobs. Please do not issue this permit, issue an administrative order, stop this process, and get the information that's required. This is not, there's no precedent, Mr. Feckert, at any time, anywhere, of ANR allowing an applicant to, without agency approval, to slice open, push off a drainage layer, push off a topsoil layer, and slice open a synthetic cap without agency oversight, and then waive an engineer's sign off. Unprecedented. And this is shameful. And I'm not blaming staff. I know the pressure's from on high. This is to you, Julie Hackbarth, and to you, John Beeling, who's monitoring this. Wake up, fix this now. Thank you.
All right, thanks, John. Looks like we got a couple more hands up. I'm just going to do them in order because I'm not sure who's here first. Marie, Thomas, do you want to go ahead?
Okay, I concur with most of the comments that I've been hearing here. I just want to know what you're going to do with the results of this meeting. What are you going to do with all these comments? And what is your timeline? I've seen it before where, like on environmental impact statements, people give lots of comments and they file lots of things, and all the comments are supposed to be addressed, but within 30 days later, the permit's issued. So what exactly are you going to do with these comments? Because it seems to me that people have brought up some very, very important and pertinent issues regarding this applicant and their continued bad faith or their bad actions that have happened, whether it's before. You can't just say it happened before I got here, because there has to be some kind of institutional memory or going on in the agency. But what are you, ANR, going to do with these comments?
Well, Maria, we record the comments, and then we develop responses to them. So,
and how will we get to know what the responses are?
We issue a responsiveness summary, and everybody that has an email attached to this meeting will get that summary.
And what's your timeline? Do you have a timeline, 30 days, 60 days?
I'll do it as fast as I can, but I really don't have a timeline.
So there's no timelines in the regulations that call for any kind of response?
To produce a responsiveness summary, no. There's a timeline on the comments, and then, we work on them immediately, but it could take some time.
But you might you decide to suspend all actions on this applicant until the enforcement action has been completed, as others have suggested. You could also do that, right? There's no requirement that you complete the action, or you could suspend it regarding until other things are done.
That has been done in the past, so it's possible.
I'd suggest doing that because you're just creating more and more of a problem. I know I'm in one of the towns that we've tried to have conversations with the solid waste district, and it's very difficult. They don't want to accept public comment. They don't want to work with the towns to address some of their other actions that they've done that aren't the subject of tonight's meeting. But there are other decisions that they've made that definitely harm the completion of their mission, which is to encourage recycling, reduce, reuse, and recycle. And I have no faith in them anymore either. And if I weren't so busy with other things, I would volunteer to be on their board or whatever, that every town gets to do it. But I think we really need to look into what they're doing and can't let them just keep on doing what they're doing without some accountability to the public. That they need to carry out their mission to help people reduce, reuse, and recycle. So thank you.
Well, thank you for your comment, Maria.
It looks like Paul Burns has his hand up. You want to go ahead, Paul?
Yes, thank you. And thanks very much for the second round of opportunities here. Dennis, you said earlier that it's not the case that this would let CSWD off the hook. And I understand what you're saying there, because this anything we're talking about tonight is not about a possible enforcement action. But it might let them off the hook. I guess, we cannot assume that there will be an enforcement action, just as we cannot assume that there will not be. That is an unknown at this point. And so moving forward with this part of it is I'm sure you're hearing, part of what causes some of us to have considerable angst and concern there. So I think you know that, but I just wanted to give voice to what I was hearing and make sure that was clear, because we have no evidence at this time that gives us any confidence that the Attorney General will be taking an enforcement action here. They've had it for well over a year. The NOAV was issued in 2018, a good long time ago. And so if we were going to see action, it's reasonable to think that it could have happened by now. This is not the world's most complicated case, frankly. There's a lot of evidence that we all have seen now. And I guess I also want to say I appreciate the fact that the agency forwarded this on, recognizing clearly that there was enough merit for the Attorney General to at least consider a possible enforcement action in this case. But given the fact that it hasn't happened yet, and they are unwilling to speak of it, we don't know. And therefore, taking this action, the subject of tonight's conversation, and moving forward with retroactive permits for, as others have mentioned, what the Chittenden Solid Waste District called a minor amendments, is very, very concerning. Dennis, I have one question, kind of just a point of clarification in my mind. Do you see any environmental or public health rationale for needing to act now or quickly on this issue of the retroactive permit?
No, I don't.
So knowing what you know of the site and what happened there, am I also correct in assuming that there is no known environmental or health benefit to allowing that situation to just continue to exist, the glass to remain where it is right now?
I'm not understand your question.
Is there any reason that if for instance, you were to wait, if the agency said, we're not going to wait, we're not going to take action on this request for a retroactive permit until after the matter of environmental enforcement is decided, there's no known environmental or public health threat that would be exacerbated by waiting?
That's correct.
Okay. So I I have a recommendation, which is that I don't know that you've got a formal policy for figuring out how to deal with requests like this application for a retroactive permit. But my thought is that it would make sense, particularly in cases where there is litigation, potential litigation at play, to wait until that decision is made about an enforcement action before moving on the permit. And certainly in this case, I think all that you've heard tonight and other things that you're aware of speaks to the value of waiting for that enforcement action decision to be made. And of course, VPIRG's position is that there should be enforcement action taken against CSWD in this case. And in part because of the fact that what we've heard tonight is, if waiting would present a threat to environment or public health, then I understand why you would go through this process of figuring out, should we go through this retroactive permit? If we don't grant it, they've got to dig it up. And maybe there are some cases where that would be ameliorating a potential threat. And of course, I can understand the rationale of acting quickly. But this is the opposite of that from everything we've heard, that it may make sense not to dig it up at all. And I'm not an engineer, and I'm not going to pretend to be one. I don't know what the right answer there is. But I do think it is bad policy to move forward by even entertaining the notion of a retroactive permit before the enforcement action decision has been made. So I would encourage you to think about that in general terms for these things and in the specific case that you have in front of you here. And just I thought Pat Austin's decision, in conclusion, I will say Pat Austin's suggestion that this is somewhat similar to taking a deer out of season, he said, I would say it's similar to taking a deer out of permit. And if a person was caught and then requested a permit, of course, that would never be granted. And it wouldn't for obvious reasons, because that would encourage other people to take deer out of season, hoping that they would never be caught, but recognizing that if they were, they could just go back and request the permit then. That's not what we want to encourage here. You want to encourage good behavior from the start. And I think that in this case, that means no action on a retroactive permit. That is to say, no action yet on the decision of what to do with that glass that was already dumped in those cases that are before you now until after the Attorney General has acted. I will be quiet now, but I really do appreciate the opportunity to make these additional comments.
Yep, and I do appreciate your comments, Paul.
Thank you, Paul. Denise Wheeler?
Hi, Denise Wheeler again, Town of Calais. First off, I just want to say that I would hope that Julie Moore, as the Secretary of ANR and as a certified civil engineer, that it would be really disappointing and speak to integrity of the process for her to waive the engineering requirements. And secondly, our town is a member of Central Vermont Solid Waste Management District. We pay them money every year in belief that they're monitoring and supporting the correct practices of recycling. And as somebody who recycles on a regular basis with Casella, who probably believes that everything was being done correctly as well, I think it's really disappointing to find out that things weren't done correctly. And I want to know what refund Central Vermont Solid Waste Management District is going to receive to pass along to towns for their Chittenden Solid Waste Management Districts not doing things correctly.
Well, thanks for your comment there, Denise, but that's really beyond the scope of these two amendments that we're talking about. But
well, not really. Why would you give them an amendment to something that they haven't done right in the first place?
Well, no, I was talking about your financial.
It could be written in, well, it could be written into the permit. You can write anything you want into a permit.
Not really, but we'll take your comment and we will respond to it. So thanks for the comment.
Thank you.
All right, we got one more hand up, and it just occurred to me, I don't know if we reached out to the folks on the phones, and I don't know if there's a mechanism to unmute. If anyone on your phone would like to speak up. I think it's *6 to unmute. If you want to try that and then see how it goes. I apologize. We're new to this virtual meeting thing and the phone line is brand new. So feel free, if anybody's on the phone and wants to speak, just try *6 to unmute. And in the meantime, looks like we got a hand up. I'll go to Pat Austin.
Yeah, can you hear me?
Yep.
Okay, so my question is to the agency. So Chuck and Dennis, you guys know what diversion rate is? Probably a rhetorical correct question. But you know what diversion rate is, correct?
Yep.
Okay. So that is, for people that don't understand, that is the way the state's calculating the success of Act 148. The municipalities and districts report the material that's been diverted from the landfill, weigh it against the material that went to the landfill, and that shows how well we're doing. In light of what's happened with Vermonters glass, will we be recalculating the diversion rate for Vermont, knowing that this material was not recycled?
I really can't speak to that, Pat. I don't do the diversion reports, so I don't know how they acquire that information. So
if you were to permit this after the fact, we would know that this, whatever it is, thousands of tons of glass did not get recycled. We would have to recalculate that. This was reported as being recycled on their annual and monthly reports. They sent the Agency of Natural Resources reports saying they were recycling them. Is that a concern for the agency that we send them numbers? The reason I ask is I'm a member of the Northeast Kingdom Solid Waste District, and we have meetings, and we sit in meetings and we look at things like how well we're doing and what we're doing with the material, and if numbers are starting to climb because of more activity. This material flowed to this facility. This material ended up being landfilled or leveled a compost facility or an embankment. Is it still the agency's stance that was recycled material if they were to permit after the fact?
well, I think the after the fact permit assumes that the material was reused.
For on the hierarchy, right?
It would still be diversion, but
you showed was it Tyler, the guy from the Chittenden, that had the hierarchy on the best use of this material, right? So I mean, it seems as though that this district took the avenue of the lowest avenue, which was down at the bottom, to landfill the glass, even though there was other options. There was other options for this district. And there's two MRFs in the state. There was another MRF in the state that was sending this for recycled use, for actual benefit of the material, because that's why we put the effort in. I don't believe that anybody at the agency, and I like I said, I'll say again, I have respect for Dennis and Chuck here, and I believe that I can see in some of your responses that there's pressure on both sides here, and I'm concerned that when this meeting's over, there's going to be pressure that is going to let this meeting just go by the wayside, even though we brought up a lot of very, very good arguments and a lot of concerning arguments for Vermonters that people want answers for, that may go by the wayside. I personally have sat in on some other meetings involving the Agency of Natural Resources with some very heated and high level permits that were eventually issued. And I feel right now that because of this situation and this even being considered for Chittenden Solid Waste District, one of the statements that I made was, if we can't trust the Agency of Natural Resources, who can we trust? And I made that statement in a public meeting with some of you there, and I feel like I want to redact that statement right now, because this should not even be on the table. And I think deep down inside, you guys feel the same way. I respect you're under some pressures from people that don't matter for Vermont environment standards. And I hope that, like Paul Burns said, that if nothing else, if you can't deny this application for whatever them pressures are, that it's delayed until there's an enforcement action. And I guess I'll end by saying this is not right, and this is not what Vermonters want. It is not what Vermonters expected when their recyclables were put in that blue bin.
All right, thank you, Pat. I thought I saw one more hand up. Annette Smith, go ahead.
This is Annette Smith. So I think I understand the cap line fill being opened up, but I'd like a bit more clarification on the other site, where I understand that there was basically a change in the landform. And when did that activity occur?
Annette, you're speaking about the south field at the compost facility?
Right, that one.
Yeah. In 2014, they started the project. Then they put it aside for a little while, and then finished it up in 2016.
And this is where glass was basically dumped over the bank, right?
No, this is where the glass was used as a sub-base drainage material. Where it went over the bank is we're not talking about that. That's not one of these two projects.
So in terms of your process in the solid waste division, had this come to you as a permit application, would you have been looking at a variety of materials? Is the glass the normal thing that you would use in this place?
Yeah, as you said, it could have been a variety of materials. It's up to the applicant to present to us what they want to do, what materials they want to use, and then we investigate that, look into the materials that they want to use, and decide whether that's appropriate or not.
So what other options would have been available for the agency to review at that time?
Do you mean, so like instead of using glass on this project, well, if they would have, let's just say they wanted to use sand to level out this field and have it drain, then they wouldn't even they would have to get a permit because they have a certification on the compost facility. So they would have amended their certification for whatever maybe they made the south field a little bigger, whatever. They would get an amendment for that, but then they would just tell us, well, we're leveling out this field and we're going to use sand, for example.
So they could have told you they were doing that, but we're going to use glass.
Yes.
Would that have, at the time, would the agency have any role in what material was used and what was appropriate? Would it be designed by engineers? How did it work, and how is that different from what we're seeing now?
Well, as I said earlier, so they'd say we wanted to use the glass. We would ask them, does it meet the PGA spec? Is the glass, up to spec? Just basically give us the plan how you're going to do this project.
I can speak to that too a little bit as well. Typically, when an engineered project comes in, the engineer has design specifications for each layer of material, for lack of a better term. It's going to meet a certain performance criteria. So if it's a sub base, you want that to structurally hold up and not just mush out all over the place when you start driving over it with equipment. So they would the design engineer would assign, design specifications that the material could be tested against to prove that it would be a suitable use physically for that layer. I think glass, as referenced by the PGA process glass aggregate acceptable use policy, is acceptable for road base, sub base. So it's kind of falls in line in that regard for that particular use. But the engineer would design it, and then any material that they could source that would meet that design spec could be sourced to use for that layer. I hope that helps clarify.
Thank you.
Ben, I think you're muted.
Yeah, I realized that. Thanks, Dennis. Go ahead, John.
Yeah, just clarification and follow up to Annette's line of questioning, I guess, Ben. So is it the agency's understanding that the glass that was placed by CSWD at the Southfield organics composting site met the PGA standard? Is it your understanding it does?
No, I don't think we've stated that in the certification.
Okay.
That's under contention.
So,
that's why we called it glass processed at the MRF.
Okay, so why is that not being required to be removed? Why is it being permitted? Is this permit operating as a waiver of the PGA standard?
I don't. Go ahead.
I was just going to say, John. So we have the acceptable use procedure, not the PGA procedure, but there's a process that folks can follow to obtain an acceptable use. It can be for any material. I mean, we're focused on glass today, but there is that process in place. So if they wanted to seek approval to reuse some other material for X, Y, Z use, we do have that. So this, we're not saying, in my mind, we're not saying in the draft amendment that this meets the PGA policy, but we're saying that the material that was sent through the MRF, whatever those years were way back, are suitable to be used as a sub base in this instance. That's the way I look at it.
Okay, well, I don't understand this instance add-on. I guess I see this as precedential. You have to treat every person across the state that you have that you regulate and whose activities you regulate equivalently, right? Ben, are you with me on this? You agree to that?
Yeah, I follow you.
So anyone else who then wants to use this off-specification crushed glass material, then based on this precedent, you will grant them a permit now and grant them a permit after the fact if this goes forward.
I think they have the opportunity to apply. I think that's what we're saying.
No, wait a minute. So if all things are equal, if I have a field in South Barry, Vermont, and I want to use, crushed glass with contaminants in it, and by the way, I have samples of this material that I can provide to you. There are actual huge bottlenecks and toothbrushes in there, among other things. But if that is okay at this location, then, and it's not a lined landfill, there are no barriers, it's outside of a currently certified solid waste facility footprint, but you're proposing to permit it now, issue it a certification. If I apply for the same thing in South Barry, identical, same groundwater separation, same setbacks to property lines, all things being equal, you will then grant me that same permit, correct?
Yeah, that's consistency, right?
I'm looking for a yes.
I just said yes, that's consistency.
Okay, so this is a
and
precedent.
I'd also like to say, John,
Okay.
this kind of speaks to Paul's comment of waiting for the enforcement case to play out.
No.
Because
if
there is a fine and you want to do the same thing somewhere else in South Barry and pay a fine, that's the deterrent.
No,
that's why
I'm talking about in advance. I come to you tomorrow with an application I've got substandard crushed glass. It's all kinds of sizes. It's got greater than 1% plastic, metal, wood, toothbrushes, tampon dispensers, type contamination in it. You will grant me, and it's identical to Chittenden, because I got samples of it, and I can show you the Chittenden stuff that was used. Would you approve that? I want to use that for fill. Based on this permit.
Is there anything in the new rules that will be effective on Halloween that would be different than what we looked at for this situation that was retroactive?
Well, you no longer can dispose of glass in the landfill, so you can't. If this is an example of what John's talking about, if it's disposal, though, no, you cannot do that. We've taken that out of the categoricals. So.
No, this is a reuse, right? I'm understanding this is being used in lieu of gravel, and it's been approved for under this permit for use at this composting facility.
Yeah. Well, all I can say to you, John, is point well taken, and I appreciate your comment, and I see where you're going, and I understand it. So.
Okay.
Thank you for your.
I would hope you guys would implement and apply your program standards in an even-handed way.
Thank you, John. Looks like we got a couple more hands up. Joseph Gresser.
Hello, I'm Joseph Gresser. I'm a reporter from the Chronicle up in Barton. I have one question, which is, in the event that the decision is not to grant a permit, what would the practical result be?
Well, once again, that's in flux right now. What that would mean? It could mean, as we've spoken of earlier, the removal of the glass. Could mean a number of things.
I don't want to push too hard, but that's a very vague answer. And given that there is a permit process in place and people have asked for permits before, it would seem to me that there is a standard for what happens if a permit is not granted.
There is, under a normal situation, this is an after the fact permit situation, which puts us all in a difficult situation. Normally, if a permit is not granted, then the activity does not occur. So we're in a little different ground right now.
So, are you essentially saying that they have you over a barrel?
No, I'm not saying that, but
Okay, well, thank you.
Thank you, Joseph.
Denise Wheeler, go ahead.
Yes, I just happened to notice that Kathleen Gent, the executive director of Central Vermont Solid Waste Management District, is on. I don't know if she's still there, but I find it interesting that it would be like to know their position on the fact that they trusted that what we were getting as our guarantee of recycling, and it didn't happen, that they would be strongly advocating for some kind of a refund of money to her member towns. And I haven't heard anything that they're outraged by this. So I just want to put that out there, that I'm just disappointed not to hear that they're concerned about everything that's gone on here.
This is Kathleen Gent. Our board discussed this last year, actually, or early this year, and said they wanted to wait for the Attorney General's decision, and
That's where we are as a district. In terms of, we don't have any contract with CSWD or any services, and our board would need to discuss any aspect of this matter further, but we're really waiting for the Attorney General's action to be completed.
But they could issue a permit before that happens.
Our board would need to talk about it, and they haven't at this point. And obviously, something like that, we'd have to confer with an attorney, but we're not. The board hasn't taken a position of doing that yet.
Okay. I don't see any more hands up at this point. So I guess I'll just, oh, I do see one hand up. Go ahead, Pat.
So I guess anybody that was on this meeting, or if this is, I guess this might be a question for Dennis, is this is going to become public record? This will all be part of the process. This is not going to be just a meeting that was held and there was questions asked. Is that correct?
That is correct. It's part of the process.
Yeah. So I have seen two people that have come to this meeting and presented from CSWD that have advocated for this permit after the fact. A lot of very good points that have come forward about why we're confused, we're having this discussion, why we're discussing this after the fact. Joe Gresser had a good point. What happens if you don't assess the permit? Do they have you over the barrel? And as a Vermonter, I'm really concerned that there is pressures that are trying to allow this type of activity. And, if you want to allow the glass to stay underneath the cap of the landfill, I'm not going to lie to you. I probably agree that might be the best avenue. Do I agree that letting something like a solid waste district, the largest one in the state, that processes half of Vermont's recyclables, to be allowed to do this type of activity when they've already been involved in enforcement action on this type of activity? I don't agree with that. I don't think anybody here does, not even you, Dennis. I don't think that anybody will be satisfied in the state to know that we can trust Chittenden Solid Waste District to continue to run the MRR that they have now. My personal feeling is they should be a solid waste district in charge of enforcement and outreach. They should not be allowed to market materials or process materials any further. They have proven that they are not trustworthy to do that. And I'll say again that if this permit is issued, this is the notice I will give to redact my statement that if we can't trust the Agency of Natural Resources, we can't trust anybody. You give this permit after the fact for years of misuse of Vermont's recycled glass. It's either the people involved, the people that are allowed to give that permit, or the whole agency that is on the hook for that.
All right. Thanks, Pat. I don't see, every time I say that, there's another hand that comes up. John. Brabant, go ahead.
Yeah, hi, thanks. Looks like we got time. Let's burn the candle. So, as I said earlier, I used to work at the Agency of Natural Resources, and folks who were there with Chuck and me back in the late 80s, who are now long gone from the agency anyway, used to tell us stories. And folks from the on-site program would tell us stories about how a developer who's still alive and well, Howard Minash, actually his son runs the business, used to build housing developments without getting any permits for septics or anything. No 250, nothing. And Act 250 and ANR did not have an in-house enforcement program. And he literally went to the AG in their discussions and said, why did I build without permits? Because it's better to build and build where I want and how I want and ask for forgiveness later. And that was actually instructive and was brought to the CUNY administration and was a cornerstone principle, and it was testified about numerous times for our legislature in the development of the Uniform Environmental Enforcement Law bill that now became law in 1990. That law is built around that attitude, getting rid of that attitude, preventing any kind of incentive from being out there in our universe from that might incent folks to seek permits after the fact, to avoid seeking agency approval overall, to avoid seeking environmental review. And that law, go back and visit that enforcement law, folks, and read it. Don't look at how your attorneys who avoid court at all costs do it. Look at what the law says. Look at emergency orders and the strong language in there. I'll bet you haven't issued one of them since I've been gone. I know you haven't. You have all these tools at your disposal, and you're spending tons and tons of public resources, including this meeting, trying to figure out a way to mitigate the damage to CSWD, not against us, the public, who were defrauded and severely impacted. This is painful. Knowing that every single bottle that I recycled, every single one, which I know every single one went to CSWD, was dumped over the bank or dumped in this landfill or dumped at that compost facility. And here we are moving forward as if that's not a big deal. Why do we have these programs if it's not going to be taken seriously? This is a big deal. This is not whether it's inert and it's going to be a source of leachate. This is something more than that. If I took a bale of milk jugs, a 4x4 bale of milk jugs, and threw it in my field, it would pass every leachate test that you might apply to it. But it's still illegal. It has nothing to do with polluting groundwater. Our solid waste laws also regulate behavior and regulate to prevent stuff from being discarded in the environment generally, whether or not they cause chemical contaminant to enter the groundwater or soil or not. So I just want to wake everyone up. We are so far down the wrong path. This is not where we should be. This is a reward. And what it's going to do is, now there's a record that CSWD's attorney is going to bring to the negotiating table. And by the way, it's clearly the strategy. That's why the AG has been talking with you all and indicating, please see what you can do about getting them permits. It's a strategy to temper and reduce the level of infraction. This despite CSWB being one of the most knowledgeable, if not the most knowledgeable entity in the state of Vermont on solid waste law, short of ANR. As Paul Burns said, they have in-house engineers and everything else. And I also want to bring to your attention, while all this was going on, CSWD had a lobbying firm, Adam DeCrassen's lobbying firm, and staff lobbying at the State House to eliminate the bottle bill. And when they were asked in committee,
John, this
what
seems
about
a little
the glass?
off topic.
Well, no, it has to do with this.
Seems a little off topic.
No, it has to do with this, exactly. They were asked, well, what about glass? We hear it's hard to market. We take care of our glass. We have markets. We've been doing fine. We don't need the bottle bill anymore. Well, they were dumping it illegally in this landfill and at that compost site, and as we know, elsewhere at the big pile. Folks, this is hurtful. This is hurtful. Please do not do this. Please go back and get the materials you need from the district and make them justify that this meets standards, that recapping meets the standards. They can't. And if they can't, then you don't issue them a permit and you deal with it through the enforcement avenue. You don't permit this. And there's no reason to. You weaken your hand, you increase the responsibility, you shift it from CSWD to ANR and the public, the Vermont public who funds ANR. We should not be taking on this responsibility. We didn't do it. We have clear laws. They know what the laws are. They know how to follow them. They have in-house engineers. Josh Tyler knows what the law is. He's eloquent in his testimony about the law. I've heard it. They can't feign ignorance. Don't do this. One last anecdote. The agency back in 1992 issued a draft certification for a waste incinerator in Rutland. I testified against that as a state official, who actually, that was my project, because I was being told, quite frankly, like you are, to push this through and find a way, stand on your head, read the law through thick glasses or dirty glasses or what have you. They went back and said, you know what? Why are we doing this? This makes no sense. It doesn't meet the law. It exceeds their air quality standards for hazardous air contaminants, et cetera, et cetera. It would undermine recycling. That was a cornerstone of the denial. And they went back and they said to the applicant, look, you need to meet these following tests, because based on the public comment at our draft certification hearing, just like this, it's been brought to our attention and we become increasingly aware that this facility does not meet the solid waste regulations or the air pollution control standards, which the solid waste program is tasked with also reviewing facilities under in that instance. They could not meet the standard. They attempted, they submitted supplemental information, there was a back and forth, and ultimately the certification was denied. That's the process. If it doesn't meet standards, you don't waive everything. If you're going to waive an engineer standard, the reason for that was for lowbrow, low-risk applications, a roll-off at a town transfer station, a little recycling bin in the town of Alberg. It was not meant for one of the most critical engineering activities that you regulate. That is the seaming of a landfill cap. Oh my God. And a situation where the engineers won't even, no credible engineering firm is going to sign off on this. And I think you all know that. I think that's why you haven't pressed them for that engineer's sign off and the as-built drawings and the as-built certifications. Again, Julie Moore, Secretary Moore, is a civil engineer. My town of Calais has hired her. She's highly competent. She's highly reputable. And this is not how she rolls. I think you should have a conversation directly with Julie. She's wonderful. She's skilled. She's a genius, I think. And this is not how she would roll. I just got to believe that she doesn't fully comprehend or hasn't been fully educated as to what is going on here. So please do that. Let her see this video. Provide her the comments that have been provided tonight. And let her make a direct decision here. Don't have her delegate it down to Chuck or Kathy Jamison or somebody else and pass the buck. It's issued in her name.
Thanks, John.
Thanks for having this, by the way. I know
hand
it's
up.
difficult with COVID. This venue works really well. Thanks so much.
For trying. Thank you for that feedback. We got one last hand up. I think this will probably be the last comment given time. Pat Austin, go ahead.
Thank you. This last question, I got one question and then one final comment. The question is going to be directed for Sarah Reeves at the Chittenden Solid Waste District. I would like to know if any glass at all during this period was recycled that came out of that MRF. Recycled, not when you say reused, landfilled, leveled. Did you send any of this glass that Vermonters sent to that facility to be repurposed?
Pat, are you asking, did we send anything to be recycled or repurposed?
Recycled.
The answer is yes.
And what process and what was it recycled as or for? I mean, there's a lot of different options for glass. You can make a lot of different things with it, whether it's another bottle or fiberglass or. So, what facility was it sent to, and what was it used for?
And again, and I'm going to go back to Dennis and Ben. I don't believe this is relevant to these permits. However, that information is available. I'm happy to provide it at a later date, but this is any for these questions.
That's called the
Vermonters,
dance.
recycled glass is not relevant to the after the fact. Okay, that's fine. So,
Pat,
so I
it
get
is,
it.
this meeting is about the two draft amendments,
Yeah.
so
Yeah.
I know that's
So
sort of
that-
tangential to the question, but that we're going to have to keep it just to that.
That's fine. I wouldn't want to put the director of the Chittenden Solid Waste District on the spot with the answers she don't have. So my last comment is for Dennis, Ben Gothier, and Chuck. I hope you guys feel highly enough about yourself to hold your integrity up, to take the right information back to your agency, and we've asked direct questions. You've given direct answers. I asked direct questions of CSWD, and their answer is, I can't answer that. That's not pertinent. I think Vermonters would like to know what happened with their glass. But I hold the agency to a higher standard than CSWD, and I hope you guys don't let me down on that.
All right, Pat, thank you. That's the final comment for tonight. It's 8 o'clock. I just wanted to remind folks just a bit of administrative stuff. Formal public comments can be submitted through November 10th. You can do that through the environmental notice bulletin. And we're going to double check to make sure tomorrow that the public comment period is open. I think John Rabant mentioned
Mark
that.
Hall has.
Hey, Ben, we have one more hand up, Mark Hall.
Oh, Mark Hall.
Can we take it just really quickly?
Yeah, sorry, good catch. Mark, go ahead.
I don't have any comments. I must have just hit the button.
Oh, perfect. So yeah, like I was saying, November 10th through the E&B. Thanks, John, for that comment about the comment portal being closed. We're looking into getting that reopened. We haven't done a lot of these public meetings with the new system, so we're working out a lot of the kinks internally as well. So that was helpful.
I got that sorted out today with Carol. So
good.
It should be open tomorrow morning.
Okay. So public comments can be submitted directly through E&B.